In a huge blow to the government, the Supreme Court today dismissed the centre's argument that leaked papers cannot be used as evidence in the Rafale jet deal case and says it will hear the review petitions and fix a date soon. Importantly, the court upheld freedom of the press, saying that the 3 documents published by the Hindu will be examined by the court and that the right of such publication is in consonance with the freedom of speech. The bench, headed by the Chief Justice of India, said in a unanimous order that the court cannot be refrained from reading the documents. In March, the Attorney General, if you remember, had argued that the papers were stolen from the Defence Ministry and even threatened to invoke the Official Secrets Act. These papers, the Hindu published, formed the basis of a series of stories by N. Ram on the jet deal, raising serious questions on the processes adopted. Last year in December, the Supreme Court had said it was not its job to get into the pricing details and said there was no substantial material to show any commercial favoritism to any party. Joining us first on Left, Right and Centre tonight to talk to us about the implications of what has happened in court today is one of the leading petitioners in the case, Arun Shourie. Mr. Shourie, thanks for joining us tonight. How important is this, what the Supreme Court has said? And I'm asking you to wear 2 hats today. One is, of course, as a former editor. You've been an editor during the emergency. You know how important freedom of the press is. From the press's point of view and also politically, how is this order significant today?
I think it's a very, very important order because, as you know, the Supreme Court of India has been one of the great courts in the world in regard to the freedom of speech. They've always preserved it. And in this case also, that's what they have done. And in fact, therefore, it's very important for our petition that they will hear it on merits. And it's very gracious of them that they will hear it not in chambers, decide among themselves, but they will hear it in open court. Secondly, it is very important for enforcing accountability in public life, and thereby enabling, and for doing that, to enable the media to do its job. The government had claimed privilege. They say the documents are in public domain. Where is the question of privilege? Official Secrets Act. In fact, the Attorney General had gone so far as to threaten in open court that we will proceed against the journalist, we will proceed against the paper, we will proceed against the advocate, we will proceed against the petitioners. He had said this. I was astonished. He is such a senior person and has, I'm sure, argued cases of free speech. But he said this. And the court has completely disregarded and brushed that aside and said that no, these questions of privilege do not arise, official secrets doesn't arise, and none of these things can be a cover for wrongdoing. But that's the judgment of Justice Gogoi and Justice Kaul, and they cite the cases from Ramesh Thapar's case onwards till Pentagon Papers and others which we
in fact, yes, they
submitted.
cited the Pentagon Papers and
yes,
and
Prashant had drawn special attention to
now,
that. But second, I think, if I may just, Nidhi, one point, Justice Joseph's judgment says I concur with that and goes much further, because he says that since 2012, the Indian Parliament has brought about a complete revolution in regard to public discourse and public accountability of governments, that under the Right to Information Act, even those organizations which are exempted from the Act, intelligence
like
agencies, RAW and all, but if there is an allegation of corruption, a charge of corruption which is well documented, or a violation of human rights, as let us say in Kashmir, then in regard to them, documents have to, even in regard to those organizations, documents have to be brought into the public domain.
What is also important about these documents, Mr. Shourie, is that no one, and that's something the court order also talks about, the judges have talked about that today, is that no one really from the government side disputed their authenticity. It was more about, well, they were stolen, that later became they were photocopied. And you have actually said that by actually saying that these documents were stolen, the Attorney General is only confirming that they're genuine.
Actually, he did a great service to all of us by saying they are stolen and that's why we'll do this, that and the other. That itself proved that they were genuine. And in a series of judgments of the Supreme Court in the past, the court has held it does not matter how the evidence has been procured, but if it is genuine, which the Attorney General proved it was genuine, and second, if it is relevant, then we will consider it. And therefore, in the 3 judges have confirmed the earlier judgments of the court in this regard.
One of the other important arguments you've made is that, the government's assertion is that the documents should not be examined because this is a matter that's related to defense procurement. And what you have said is that because they relate to such a vital issue such as defense, they need to be examined. And
yes.
that is where you think the court also finally sort of veered around to that.
That's a wonderful thing. That's a wonderful, very important point. Because the Attorney General had kept arguing, oh, this relates to defense. So 2 points on that. Firstly, defense was being used in a very loose way. I mean, land acquisition, let us say some defense land is given away in one place in West Bengal for collateral considerations to a builder. You can say, oh, defense. So the game was given away by the affidavit filed by the Defense Secretary in this very hearing. He said these people are giving away the war capacity of combat aircraft. But there was not one document, there was not one submission of ours which had anything to do with the war capacity of the combat aircraft. If I say that this
sovereign guarantee is not there.
Sovereign guarantee is not there, or offset clauses have been changed retrospectively.
Or the PMO intervened or whatever.
There were parallel negotiations, or that you had these, all sorts of things that were done. The corruption clause was removed. How does that give away anything about the war capacity of the combat aircraft? And I think the court saw the merit of that argument of using this point about defense loosely. And secondly, as you implied, precisely because it deals with defense and therefore the lives of our security men and the security of the country, you must examine the evidence.
What the Ministry of Defense today has said, though, in a statement is that it said that some documents just couldn't have been placed in public domain, but that these documents that are being presented are being done so selectively and presenting an incomplete picture. What would you say?
Nidhi, the best way is for them to please give the full documents to the court, then they will not be selective. And they have not said what is the other document. Is there another document which says that retrospectively the offset clauses were not amended?
Or that
is there a document to that effect? Or that there were not parallel negotiations going on? Or that the Defense Secretary did not write on file that the position of the Indian negotiating team has been seriously weakened, his words, by parallel negotiations going on from the Prime Minister's office, or that the National Security Advisor, without any authority in law, had gone and made commitments and accepted terms which he was not allowed to do. Show us the complete documents on that. So you can't say selectively and just think that everybody will just swallow and vomit what you say.
Do you think that this whole notion of stolen documents, which then got changed to photocopied documents subsequently by the Attorney General, and this threat to invoke the Official Secrets Act, do you think this all came as somewhat of an afterthought to the government in this entire argument?
And
why so?
Because Nidhi, it's a very important point. That's a very good point. These documents were being published from November. One of the documents was in our petition. In a petition which we had given, it was annexed. Then the Wire, Caravan, they started publishing in the middle of December. NRAM started publishing his stories on the 19th of January. And it is in the Defense Secretary's affidavit, it was said, oh, such secrets are being given, combat aircraft and all this. And that we have instituted an inquiry when? On 28th of March. On his affidavit he says.
So the Attorney General made this comment on the 6th of March in court.
But 6th of March.
Yeah.
And the interesting point there is that if you were so concerned about secrets going on and you are sitting and waiting till the 28th of March for the investigation to be started, that was just an afterthought. So I think what government just could not answer on facts. So they tried to put a hurdle right in the beginning. And the substance of the matter is that first hurdle has been crossed, and the Supreme Court has graciously agreed to hear the petition, our petition on merits. And if I may say so, there are two petitions that are related. One of them is
the review of the order itself.
Because you have been, not because the court is wrong or something, but because you have been too trusting of the government, what the government submitted to you. You just took that at face value, and we have shown how that led to various errors. And secondly, that because the government did this deliberately, because it was not just one grammatical misconstruction, it is a series of things which they misled the court on, and a series of facts which they hid from the court. For instance, the meeting, they said all the processes are finished, let's say on the 21st of August in a particular year. But there was a subsequent meeting of the Cabinet Committee on Security on the 23rd of September, in which 9 changes were made which were kept from the court.
So that's what these 2 review petitions are now.
Therefore, we have said one is, therefore, review your judgment because you were misled. But secondly, because they misled you, you have to bring them and consider them for perjury.
Can I ask you a political question finally, Mr. Shourie, which is that, how do you see this playing out politically? We're going to start voting tomorrow in the general election. There are many political pundits who believe that as an election issue, Rafale has not had the kind of resonance among people, let's say Bofors did at that time. Do you think that politically this will have any impact on the BJP or Mr. Modi's campaign?
I think that as candidates get announced, then micro issues become more important. But as far as Bofors and Rafale and corruption and the emergency and all, I can tell you from the time of the emergency, I was told, all this business that you people are talking about is only drawing room gossip here, it's not with the people, till the election results came. At the time of Bofors, we were told the same thing, except when Jaswant Singh wrote from his village. I used to request him to write, he was my good friend, please write a column, what is the talk in your village? He wrote a sentence saying that they are saying, isne to top khane se chori ki hai. It is an area from which there is a great recruitment of the forces. I then saw that the issue has reached the villages. So I think there are too many constructions about Rafale. Elections will be decided by people on a host of issues. And in Rafale, and in all the other scams which are coming out, Nirav Modi's and all these fellows, and I mean, you can recount many more of these. In all of them, the central message that goes is that this claim that this is an incorruptible government, uncorrupted, untainted, that has been affected. So not Rafale as an issue in itself,
but a whole host of things brought together.
All of which none of which has been refuted.
All right. Well, Mr. Shourie, thank you so much for coming in today and giving us your perspective as one of, as I said, the key petitioners in this case. We don't yet know when the Supreme Court will actually take this up, but there is no timeline to this. It's clearly an issue that has been brought back to life, which perhaps the BJP had hoped would by now certainly be a dead issue. Thank you, Mr. Shourie, for joining us. Let me go straight across to Mr. N. Ram now, because he has been at the heart of this entire story. And Mr. Ram, your first thoughts today on this order by the Supreme Court, most importantly, for what message has gone out to upholding a free press. We all are able to do stories and good stories, expose scams, scandals on the basis of documents that we obtain, and at least the court today has recognized that.
Yes, Nidhi, that's exactly what the main message. And I hope that message will go down the line to the entire judiciary in India, because freedom of the press, freedom of speech and expression have come under pressure, and in many cases under attack. So I think this is an extremely important message, the Supreme Court. And let me quote from the judgment some very significant lines. And this is from the judgment written by the Chief Justice of India, joined by Justice Kaul. And the other judgment is equally important, but this is what strikes me first. The judgment says, no question has been raised, and in our considered opinion, very rightly, with regard to the publication of the documents in the Hindu newspaper. No questions have been raised rightly about the publication. The right of such publication, it's not just the Hindu, it applies to all of us who have documents like this or of some significance and want to bring them out in the public interest. Okay, the right of such publication, the judgment goes on to say, would seem to be consonance with the constitutional guarantee of freedom of speech. And not satisfied with that, I was delighted to read this. The Supreme Court judgment says, in fact, the publication of the said documents in the Hindu newspaper reminds the court is reminded of the consistent views of this court upholding the freedom of the press in a long line of decisions, commencing from Ramesh Thapa versus State of Madras and Rij Bhushan versus State of Delhi. Hurrah! Because that's what it's all about. It's the Supreme Court which derived freedom, the right to freedom of the press from the broader right of freedom of speech and expression guaranteed in Article 91A. And there are many such observations, and also in Justice Joseph's judgment,
Absolutely.
I think some very important statements and findings on the freedom of the press. The court reminds itself very, very significant. Perhaps it's a very modest statement to make. This publication reminds us of our illustrious history in upholding freedom of speech. That's the message that needs to be taken to all the high courts in the country and the entire subordinate judiciary. And then
right. Mr. Ram, stay with us. Just stay with us. We also have Ajay Shukla here with us, who's of course written extensively as well on the Rafale deal. Mohammad Khan of the Congress is with us. Mr. Deshratan Nigam is also with us. Mr. Nigam, is this not a setback for the government, which tried so hard to make this argument in court? These papers are stolen, they are classified, the Official Secrets Act, they are photocopied. Everything was done to ensure that these papers would not be examined. Would you not concede today that the court order is a setback?
See, this is not an order on merits of the case. Let us be very clear. Now, secondly, I would agree that there was a mishandling of the matter in the initial matter. When an officer like Attorney General says it is stolen and then changes a stand, I as a lawyer would be certainly surprised of the faux pas which has been committed. But then let us move on. This raises some very serious question. It talks of freedom of speech, but it does not talk about reasonable restrictions on freedom. Irrespective of the government which is in power, there has to be certain issues, without even going into these documents. I'm not speaking on the merits of the case. There may be circumstances where documents are leaked or taken away for the purpose of espionage and things like that. Those have not been dealt with this order.
So this is a flawed order of the Supreme Court?
I certainly think they should have dealt in detail. They are silent on these aspects on this, and therefore, irrespective of any government.
And who decides what those reasonable restrictions are?
The Supreme Court would have to decide.
How?
Supreme Court.
How?
They have said so.
Because all over the world, sensitive documents, I mean, are used, whether it was the Pentagon Papers, these documents, they're often used.
No, they are
used to expose wrongdoings by the government.
Wrongdoing is all right.
So every government will try to place reasonable restrictions to make sure the press doesn't do its job.
Let me come to another point now. What I am saying, those reasonable restrictions the government, the courts have laid down in Catena of judgments. It has not been dealt here in the context of Section 3 of the OSA. They have only dealt that with the Right to Information Act. So it's not a very comprehensive judgment, and it might be in due course of time in future may be reviewed by the Supreme Court itself. Now, second issue is CAG report is already there. These are the issues which has to be first dealt by CAG. Now, CAG gave its report. The only forum for discussion is the Parliament for CAG report. Nobody has challenged this.
The Supreme Court was misled to believe that the CAG report had been prepared at that particular moment, which it had not, and that the PAC, Parliament's Public Accounts Committee, had seen it, and that was not true.
No, let me tell you.
Which is what now the Supreme Court will review.
That application is pending. Supreme Court has not given its mind on that because the Government of India says that it's an error on the part of the court, not on the part of the Government of India.
I'm not here to. So, Ajay Shukla, I'm not here to argue the merits.
I'm saying only Parliament
because
is
we are
the
not
forum.
the Supreme Court. Ultimately, the Supreme Court will decide on the merits of the petition. It's a very simple point. Because, I mean, can you imagine what would have happened, Ajay, if the court had said the opposite? That, there are restrictions, that, the press will have to have restrictions on the kinds of documents it's able to publish. I mean, this would have had catastrophic impact on the way the media functions.
This would have been a landmark finding by the court had it imposed these curbs on the media. To take on what Mr. Ram was doing, which is to quote from the judgment, they've actually quoted from the Official Secrets Act all those threatening clauses that the government had included in its submission, which is that people can be imprisoned, people can be taken to court, people can be incarcerated for making public these documents. So to that extent, this is as much a judgment about the freedom of press as it is about the Rafale. But taking a step back and looking at it from the larger viewpoint, what the Supreme Court is also doing is tacitly admitting that its earlier judgment was perhaps based on things that had dubious factual accuracy, and just
such
looking
as what
at
I was
this,
pointing out about the PAC and the
exactly,
CAG.
but that
There's
was
no
just
finding
one.
on that.
That was just
Not
one
today,
point.
but they are going to look at that now.
Look at,
yeah,
but
sure.
it can go anyway.
Yeah, of
No,
course,
it
no one's denying that, but they're looking at it.
Yeah, fine. They have a right to
just
look at it.
looking at it from the point of view of human psychology, the Supreme Court would at this point, and as evidenced from this order today, be feeling that it was led by incorrect statements, by false submissions into making a judgment which it is now somewhat regretting. So I would say, purely from the human psychology point of view, the Supreme Court will be going deeper into this matter now than it originally intended to.
Well, Mohammad Khan of the Congress, yeah.
Well, I think the very distinguished panel has covered a large number of points, both legal as well as with regard to freedom of speech. So I'll confine myself to the political resonance. I want to tell you, Nidhi, that today, if there's one person who would be acutely aware of what this means, it's our Prime Minister. I'll tell you why. People often ask us, why do we keep raising Rafale? Aside from the obvious fact that it is the single largest corruption allegation in our nation's history, we also see that it touches a raw nerve with the Prime Minister. जैसे हम कहते हैं दुखती हुई रग पे हाथ रख दिया. I'll give you two examples very quickly. First is, when we started raising the slogan, Chaukidar Chor Hai, and we found that it had a certain resonance on the ground, the Prime Minister comes back and responds with what I believe to be a very defensive and feeble line, hum sab chaukidar hain, main bhi chaukidar hu. He tries to take it back because he knows that his image is being damaged. This is resonating on the ground. People are looking at these facts and arriving at a conclusion that our Prime Minister is not as above board as he seemed. The second point I want to make to you, and I'll conclude on this, you will remember a few days ago, a colleague of yours was interviewing the Prime Minister, and she asked him about this deal, perhaps the first time in public memory that a journalist has actually asked the Prime Minister. The Prime Minister,
What a shame we have to applaud
visibly,
that. But anyway.
but the more interesting part is this.
His
Visibly
response.
rattled Prime Minister goes, you don't believe in the Supreme Court? You don't believe in the French President? Aapko bharosa nahi hai? To which I would conclude by responding, the French President, Mr. Hollande, said that you compelled him to pick Reliance as a partner. And the Supreme Court today is exercising its rare power of judicial
you're saying the
review
government is rattled?
because you lied not on one or two, but 5 different counts. And these new documents prove that. That's all I have to say.
Mr. Ram, I have to ask you that, you've been doing a series of stories on this issue, and the latest one was out just yesterday. Are we going to see more in the next few days and weeks?
I'm sure my friend Ajay Shukla, former colonel in the Indian Army, knows a great deal about it, and I'm sure they're all working on these things. Yes, there could be more, but you wouldn't expect me to say too much about it on national television. But now I just wanted to make the point that these 3 documents, they seem very few, but they cover practically all the issues. Ajay would bear me out on this, that figure in the Rafale deal, and particularly that 8-page document where the 3 domain experts have covered all the ground, benchmark price for a fully fitted combat-ready Rafale aircraft, the exorbitant cost of the India science, design and development, India-specific enhancement, lack of sovereign guarantee, lack of bank guarantees, and all these issues are deleting clauses belonging to the integrity laid down by DPP 2013, that is the defense procedure. Everything is covered, and the other 2 documents cover the whole business of parallel negotiation. Now, they accuse
By the
me
PMO.
by the PMO and also by the National Security Advisor, who actually led these. It turns out, if you look at all the Indian negotiating team's final report, July of 2016. Now, they accuse me of propping a document. Let me clarify once and for all. We published what we got, and 45 days elapsed between Mr. Sharma's note testing against the PMO of undermining the proper negotiations, and the defense secretary the then defense secretary, Mr. G. Mohan Kumar, in his own hand, endorses it, complaining that undermining these negotiations. And Mr. Manohar Parrikar, an extremely efficient minister who acted promptly in most, we know that, could not make up his mind. What does he say in his hand? And why did it take 5 days?
Yeah.
Why did it take 5 days to reach that stage?
And what is important is as what you're suggesting, Ajay, is that you believe now that the Supreme Court, in a sense, is going to revisit all of that. Because one of the things the court said in its original order in December was that it is not the court's business really to go into the issue of pricing. They may not still do that, but do you think that they could very well then look at whether proper procedures and processes were followed, at least?
Well, in saying that we will be, that the documents revealed by the press, howsoever they have been obtained, are relevant to the case, they are really saying, in a way, that the revelations put out by the Hindu, by Mr. Ram in particular, are all fair game for examination by the Supreme Court. That the Supreme Court will be looking at these documents, will be making a determination in this connection. And since these documents were not available the first time that the Supreme Court looked at the case and reached a judgment and a conclusion, they will be looking at this case effectively de novo.
Lens.
They will be looking at the case de novo.
Well, Mr. Nigam, last quick comments. I mean, politically, I mean, you analyze politics. You don't think this is damaging, what has happened today to the government?
No, because it is not on merits of the case, one. Secondly, even till today,
despite every attempt that was made by the government to make sure that these documents
they
are
were
not
on the
even
national security and the price, whatever, if these three documents do reveal the prices and all, this might affect the stand that they had taken. It has been rejected by the government, but it is not on the merits of the case. Still, the field is wide open, and let me tell you, till now, Rafale has not had traction on the ground. Whatever the Congress may say, it is resonating. Probably it is resonating in their own headquarters. It's fine. In a closed room, it might resonate.
Ironically, and I think Ajay tweeted about this today, today is exactly 4 years to the day when the deal was announced by Mr. Modi in Paris, isn't it?
Yes.
And where do we stand 4 years later?
4 years later, as I tweeted, not one Rafale has come, not one Rafale will be made in India, and the Supreme Court has effectively opened the case for an
all over again, 4 years, exactly to this day. Last word, Mohammed Khan.
Yeah, very, very quickly. These 4 years worth of debates, etc., could have been completely avoided by this government. The scrutiny could have been avoided by this government if it had conceded to a joint parliamentary committee, a demand to which every government before them has committed. This is the first government in our history which didn't feel the courage of its convictions to accord that. And Nidhi, aside from the questions you raised,
their argument has been the Supreme Court has looked at it. Why does the JPC?
But the Supreme Court didn't look at why you abandoned the arbitration clause, why you abandoned the transfer of technology, why you decided to withdraw a sovereign guarantee. You abandoned all the clauses that the previous government had put in place to safeguard our interests, and you hid that from the Supreme Court. आपका दामन साफ नहीं है, इसलिए आपने JPC नहीं कराया, इसलिए आप घबरा रहे हैं. This is why you hid behind an imperial law.
I think will now be determined by the court
Supreme
itself.
Court.
And when, as we've said, we don't know when that review petition will actually be, those petitions will actually be taken up. The court has to fix a date on that, but it is significant that they've decided that they will do it, and that those classified documents accessed by the Hindu are not going to be seen as privileged in any way, that the court will have a look at them. Thank you very much to all of you for joining us on that important story.